I don't hear you.
Good morning to my fellow panelists, yourself, and then to the viewers. I think we have discussed this matter before, and it's interesting that we've come back again to touch on the same subject matter. A number of issues arise, but before then, I need to put on record that some attempts to make it look like the government of Nana Addo Dankwa Akufo-Addo was not combative enough to deal with such matters, really begs the question. Because who created the office of the special prosecutor? How do you say such a person is not desirous or is not interested in fighting corruption, when indeed the first person that occupied that office, Honorable Martin Alamisi Kaiser Amidu, and a long-time, Deputy Attorney General with vast experience.
Member of the NDC.
Member of the NDC. Was the first to have occupied that office. And this is not a person that somebody can control. And if you know Martin Amidu, you know this is not a person that Nana Akufo-Addo put in there in order to know that maybe it's a person who is...
How did it end, though?
Who is amiable.
How did it end?
Of course, it doesn't really matter how it ended, but the intention was to have put somebody there to do the work. And you can see from the evidence again that the current special prosecutor was put there because he is known to be fearless. And he was our lecturer, isn't it?
No, I don't.
So he was...
He didn't lecture me.
Yeah, so when Mensabi left, so he took over criminal law just in the middle of, criminal law days at the law faculty. So knowing Kissi is somebody that you cannot really sit down and then manipulate. So I believe very strongly that the intention of Nana Addo Dankwa Akufo-Addo, the former president, to preserve the office of the special prosecutor and make it workable cannot be, questioned.
From the point you're coming from,
cannot be questioned.
From the point you're coming from Martin Amidu's point, knowing how he left, then will the claims made by the Kissi Agyebeng not be easily believable that during Akufo-Addo's regime...
I'll come to that.
No, you finish that point first.
I'll come to that.
During Akufo-Addo's regime, it was difficult for his office to function because I remember he saying that it was as if all the other sister organizations had been instructed not to deal with them. So he can't work with, police won't work with him, these people won't work with him. And that's the situation he found himself in. He was talking about a general situation. And we know that within Akufo-Addo's regime, there were about how many suits trying to abolish the office. There was one petition trying to remove him from office, correct?
Currently, there are about 15 petitions for the removal of the special prosecutor. Is it blamable on Nana?
15 petitions?
About 15 petitions.
Before,
are you going to blame
President Mahama?
No, but now.
Before President Mahama? Okay.
Are you blaming that on Akufo-Addo as well?
I'm not aware. 15 petitions.
So I'm telling you, it has nothing to do with Nana Addo Dankwa Akufo-Addo.
Okay.
But the point that I'm trying to make is that when Honorable Ofori-Atta was leaving the jurisdiction, at the time he had informed the current the chief of staff at the time. And he had also informed the transition team members, the person who was representing the current administration, the incoming administration. He had served notice on them. Now, if this was a person who was running away from justice, more or less a fugitive, I don't know who will be actively informing people that I'm leaving the jurisdiction to go and seek medical attention. That, for me, beats my imagination. Secondly, at the time that Honorable Ken Ofori-Atta was leaving town, was the OSP investigating Ken on the SML issue? We need answers to this question. Secondly, if the OSP was investigating Honorable Ken Ofori-Atta, did he actively seek the cooperation of any agency of state to prevent Honorable Ken Ofori-Atta from traveling? Because, as you know, the CID, the NIB, YOCO, FIC, OSP, routinely, even the courts, routinely serve stop notices on the Director of Immigration, Controller of Immigration, to stop individuals that are subject of investigations or suspects or persons of interest or even accused persons from leaving the jurisdiction. Was that done? Is there any evidence that a letter to that effect had been served on the controller? We need answers to those questions. Now, if he did, how did he do it? Were they letters? Or did he place call? Did he call the Attorney General, for instance? I don't want Ken to leave town. Can you do something about it? The Attorney General is alive.
Talking about the Attorney General. The Attorney General is also investigating this same matter, right?
I'm talking about the Attorney General at the time.
No, I'm just asking now. And I would like Theophilus to also respond to that.
That's right.
The Attorney General has told us that he's also investigating this matter.
Correct.
So what has he also done?
Exactly. So I'm saying that at the time, did the OSP contact the Attorney General and to seek his cooperation? And don't forget that they are mates and they are friends.
He said their doors were shut to him.
So, no, but there's no evidence.
They were like a persona non grata.
Look, in public service, your best weapon is paper evidence. Is there any evidence? Is there any text message? Can you call the then Attorney General, Honorable Godfrey, to find out for him? Because this is an indictment on those people.
So let's refocus the discussion. Let's refocus the discussion. Is the absence of Ken Ofori-Atta, does the absence of Ken Ofori-Atta make this a lost cause? That's the focus.
No, but that is
78 charges.
That is not even the case, because the law provides.
We're discussing the charges.
The law provides for mechanism for trial of persons who have absconded or are not available to stand trial.
Okay.
Or the law to continue. What's her name? Sedinam Ationu. She absconded. The trial went on in absentia, and she was convicted in absentia. You understand? But that is not even...
Sedinam Ationu.
Yes, that is the master.
She was charged.
Yeah, she was charged.
While she was in Ghana.
She was in the jurisdiction.
She was in the courtroom. And the trial was going on.
And then she left.
Then she asked for permission to travel for treatment.
That's correct.
And didn't come back.
That is correct.
Is it the same situation?
It's not the same situation, but it is similar. Because at the time Ken was traveling, he said he was going to seek medical attention. And there is evidence that Ken had...
He was not before a court.
No, not. But he was not even being investigated for SML issue. We need to find out whether at the time Ken was traveling, was he actively being investigated? No. And we need to find the evidence. He wasn't actively being investigated. And when Ken left, there is evidence that Ken went to a hospital in the United States to undergo surgery for prostate cancer. And this is a man above 60, 64, 65. And in the second week of June, he went under the knife. There's also evidence to that effect. And if the special prosecutor or the authorities within our country do not know this, then there is a problem. Because all this information must be readily available to them. Now, post-surgery, what is Ken's situation? Do we know?
Hold on.
Do we know Ken's situation?
We want answers to some of the questions.
I'll explain my philosophy to you. And it's very simple. I consider bail and sureties, or I liken it to the collateral you give for a loan. When you give a collateral that is less than the loan you take, there's no motivation to pay back. You can let the loan go run its length, and then there's no collateral to fall back, and you go into default. In the same way, bail is connected to a case. So imagine if I have a case of 100 million, the exposure or the risk. We do a lot of investigation for the banks, for example, where somebody has stolen $90 million. And then you catch the suspect, then you give him a bail of $20 million. Now, like I told you, assume at every point that every criminal is at least above average income. The fact that he beat the banking compliance and everybody to steal that money tells you he's not your average Joe.
So as you know, some of the people who have been charged for millions of financial, mismanagement or corruption. For example, Kwabena Edu-Boaheng in the National Signals Bureau's case, he was a former boss. The bail sum giving him was 80 million with 2 sureties. Alhaji Abdul Wahab of the NAFCO, 50 million. Bernard Enchibu-Esiako, the chairman, Wuntumi, 50 million. You had Charles Mensah, is in Niyama, Chatawale, he had 5 million, 2 sureties. Almost all the cases, they are looking for 2 sureties. Edwin Provençal, former boss, he 30 million, 2 sureties. And then you had the NSS, heads who were also arrested. And the courts are now reducing the bail sums for those who were not able to fulfill them. Some spend 2 weeks in jail, in custody, some spend less, because it's difficult to come up with the fulfilling the conditions. Yes, Hassan, why are you guys, even in Parliament, you are raising this issue that bail is being used as punishment?
Yes, I think that this matter again has been discussed on this same platform before. And the overwhelming view is that it appears that bail is now more or less being weaponized, being used as a weapon to oppress, suspects or persons of interest, with some very onerous bail terms and conditions. And I think that there has to be some kind of, realignment and regulated environment as far as bail is concerned. It has never been like this before until just recently. And if you have observed, there are different agencies handling this kind of cases. You have the OSP, you have the IOCO, you have the NIB, and I think the CID as well. Most of the furor and indignation is directed at mostly IOCO. OSP, you will hardly find any instance where OSP will insist that somebody must be held in custody. And not many people have gone to OSP, except maybe 1 or 2 that you hear about them in the public, especially with the exception of maybe Paul Adumochi because of who he is. And even that one, the bail conditions were not such onerous bail conditions. Now, what happened to self-recognizance bail? We're in this country for the 8 years that MPP was in power. Can you mention one person who was held in custody because he couldn't meet any bail conditions? Can you mention one?
You may not know.
You see, we have had Stephen Opuni, Seydou Agongo, Dr. Kwabena Dufour Jr., they have various chief directors, they have business persons. They were all released on bail right from the beginning. Second, you have another group, Dr. Tuforsin, Dr. Kwabena Dufour Sr. himself, Alhaji Collins Dauda, Kissi Agyebeng Mensah, and all of that. They were granted self-recognizance bail. Then you have another category.
By police or by court?
By the court. So
we're talking about the police bail first.
Even at that level.
We're not talking about court bail.
Even at that level. You will never hear it. Richard Jakpa, for instance, was he ever detained? He never slept in custody for 1 day.
Do you know that for sure?
I am telling you for a fact. So all these things about, we need to tie bail to the sums that, apparently had been lost and so on and so forth. But there are people who have been held in custody unrelated to any loss of money. So why are you still holding them in custody? What are you trying to recover from them? In the particular case of IOCO, if you go to their functions, Section 3, it provides that the IOCO would recover proceeds of crime, for instance. So in the mind of the executive director, if from their investigation, you are deemed to have caused or misappropriated 60 million cedis, then he has to give you bail conditions amounting to about 60 or so million cedis. That is wrong. And I think that the application of bail should be regulated under Article 296 of the Constitution because it's an exercise of discretion.
What Raymond said? What Raymond said?
He said his philosophy.
What's wrong with that?
He said his philosophy. Now, there are people who have occupied that office before him.
Is that philosophy compliant with the law?
It is not.
Why?
It is not. Look, we should be guided by the provisions of Section 96, for instance.
Yes, what does Section 96 say?
It provides...
What does Section 96 say should be how to deal with bail?
I mean, it talks about bail not being excessive. That one is very clear. And if you have it, we can read Section 96 copiously for the benefit of the listeners. You see, bail is being used as a weapon to oppress even accused person. Look, if you have a very solid case,
the law says
how long.
The law says you grant the bail depending on the circumstances
of the case,
but you shouldn't use the bail as punishment. It shouldn't be excessive.
That is what we are seeing.
Who determines that it is excessive or it is being...
At the point of inquiry, it is the agency that is doing the investigation that must exercise that discretion.
Right.
And it's a discretion that must be exercised, that they must exercise with, a lot of, empathy. But it appears that the whole idea is to convict you even before. We want to hold you in custody even before the trial starts. That is the whole intention. And I think that it is very wrong. Look, it has to be regulated by Article 296. But when you are exercising discretion, it must not be capricious, it must not be whimsical, and so on and so forth. But that is what we are seeing. Because the ED, for instance, when you heard, he said that his philosophy, so that makes it, capricious. And because people have occupied that office before, and we haven't seen some of these things before. It's the same law that we are applying, it's just different individuals. So he brings different philosophy to the office, and I think that it has to be regulated. It is, look, BNI, for instance, has investigated a whole lot of people. You will hardly hear anybody, maybe because he's a media person, coming from the media stock, because almost every case of Eko is in the media space, especially if it has to do with any politically exposed person. So we have to be, as a country, watch it the way that we do. Otherwise, one day somebody will need Kotoka International Airport as surety. You need a property, maybe Tema Harbour. Because the rate at which we are going, 800 million, 150 million, 100 million. I mean, how many people have that kind of property?